Okay, good morning, everyone, or good afternoon, actually. Just turned afternoon. This is Mike Volkov, and I appreciate your joining me for the anti-corruption due diligence webinar. I want to make just a couple of housekeeping things. If you send, I'm happy to send the slides out after the show. If you want to just email me, and I'll send it right back to you. Number two, I want to make sure that you can hear. So if there is any technical problem, please use the question chat box and send me a message, and I'll see that. If you have questions while we're going along, I'll try to get to them. But if you write them, sometimes I do take a look at them during the webinar, and I can try to respond to some of those. If I don't, I'll respond afterwards to the question. And I think that's about it. So please let me know if you can't hear or there's some technical problem. Just shoot me a chat question or in the question box, and then we can go from there. Well, I'd like to begin the webinar by telling you that I think this is the most important area to focus any FCPA compliance program on. And I think if you have time or you have limited resources, this is the area that you should focus on. There are various ways to tackle sort of the existing third parties that your company may be dealing with or that a company is dealing with, and to prioritize them in terms of a risk-based analysis and go back and try to take a look at them. I know that people don't want to upset relationships and try to renegotiate terms or anything like that, but there are even steps you can take during the term of an existing contract to build a better record to show that you are, your company is paying attention to the issue of potential corruption risks. So let's talk about, we're going to go over third-party enforcement risks. I also like to talk about what the law is. I think everybody, as a former prosecutor and going into court all the time, I was amazed at how many people would come in and try to, BS their way through it without knowing what the law is. We'll talk about the types of third-party intermediaries, the sort of legal differences among them, and then we'll talk about risk-based due diligence principles and practical principles that you can apply. How to deal with red flags, and then I'll go through my 10-step recipe, not for anything good to eat, but a 10-step recipe for effective due diligence. Obviously, the stakes are high when we talk about third parties and due diligence because companies have the least control over these people. These are people who are agents or distributors who are not necessarily they're not your employees, so you're going to have the greatest risk with regard to them engaging in bribery. And number one, the reason that you hire them is because they know the local people and they have local connections, and that always is going to create some issues. The other thing is the focus. And if you go through and you stack up all the FCPA enforcement actions, you'll see that 90%, if not more, dealt in some way or another with third-party problems, third-party agents, third-party due diligence problems, third parties who sort of went off the reservation, and usually it's when companies don't know that they're doing that. It's not the initial due diligence that is always the problem. It is usually the the monitoring of due diligence and monitoring of the third party, and that's where companies get into trouble because they don't do any monitoring of these third-party agents, let alone knowing who they are in some cases. Okay, so that's why this is important. The FCPA guidance, which just came out from the FCC and the DOJ, emphasize the importance of due diligence when it comes to third parties. So this is just an excuse to use the term Breaking Bad, my favorite TV show, which is coming back soon, hopefully. On third-party violations, Breaking Bad, obviously if a third party goes bad, you can suffer a lot of things, a corruption investigation, reputational harm, criminal liability. You can obviously, FCPA cases can lead to board and senior management changes. affects the stock price, at least temporarily, and then there's all the collateral litigation that comes about it. So let's start with the law. What does the law actually require? And you need to, I always emphasize to everybody, and particularly young lawyers, that you start with the law. Always just say what the law is. Look at what the law is. Don't just BS your way through it. Okay, we know that third parties are liable, but how? So the FCPA includes language, the statute includes language in Title 15 about that a payment that is made to somebody by, let's say a company makes a payment to another person and knows that all or a portion of such money or thing of value will be offered, promised directly, indirectly to a foreign government official. Okay, that makes sense. First off, you can be liable for a direct payment by a salesperson under the respondeat superior. That's you acting directly. But you can also be held liable under the statute, under these specific provisions, with regard to a payment made to a third party who then in turn makes a bribe payment. Knowing is the key here. White-collar crime is defined by knowing or defined by state of mind. Very often there's no dispute as to the events that occurred. It's whether or not the state of mind was requisite or was satisfied. And knowing here means that a person is aware of a high probability of the existence of a circumstance. So in the case of a bribe, there's a high probability that the company knows, and that can be imputed from a particular employee, or sometimes the government tries the collective knowledge doctrine, but let's just say a particular employee of the existence of a circumstance. Okay, that means the existence of a risk or knowledge that the person is going to in fact pay a bribe, or as we will see here, could pay a bribe. Liability, third point, extends importantly here to those who purposefully avoid actual knowledge. The head in the sand, okay, problem or conscious disregard. These are concepts that are included in the law and statutes and in case law. Willful blindness and deliberate ignorance. The most important part of this is the last bullet here, which means the unwarranted obliviousness. Now, my wife accuses me of being oblivious all the time, but it's the unjustified obliviousness to any action or inaction, language, or other signal, so that should reasonably alert them of a high probability of an FCPA violation. Now, this is just a fancy way of saying that you failed to react to a signal. Now, what is a signal or action, inaction, or language? To me, it means, and you can sort of shorten it by saying the red flag. You are unjustifiably oblivious to a red flag, a serious red flag, that reasonably alerts you to the high probability of an FCPA violation. So that says it in a nutshell in terms of the law, and that last statement is really what we are trying to avoid. Okay, obviously, these are the situations where the government can come in and second guess you as to whether or not you should have passed somebody through the due diligence process, and that's what we're trying to deal with that. Okay. So who are the types of third parties that we see? The types of third parties, the easiest ones to deal with are the agents who stand in the shoes of the company and they represent the company. They are basically acting on behalf of the company. Now, they can be to obtain foreign government contracts, or more than likely we see them getting regulatory approvals, particularly in India or other countries, immigration papers, customs clearance, and other services. So those types of agents are definitely out there, and you'll see lots of those in terms of the regulatory approvals or navigating a regulatory framework in a particular foreign country. The more interesting, I think, more difficult issues come up with distributors. And the one thing that came out of the FCPA guidance, which was really emphasized over and over again, is the Justice Department and the SEC consider distributors the same as agents. People try to, say there's a little bit of a difference here in terms of your ability to control the distributor, and therefore the law should have some difference. But the DOJ and SEC basically shut that down and said, you are just as liable for your distributors as you are for your agents, so we're expecting you to exercise due diligence. Now, there are distributors and there are distributors. I mean, there are so many different types of distributors. There are distributors who will act like customers in the sense they buy your products, pick it up at your factory, ship it over to their country and sell it, and they don't tell you, and you lose control of the product at the moment they take it. You have no idea what they're doing with it. You don't know how much they sell it for, whatever. You don't know anything about that. They are like a customer. Nonetheless, you can be held liable for them. The buying and taking of the ownership of the product for resale is basically one type of simple distributor. There are other distributors who purchase on credit or consignment, and they don't take title to the product, and they basically are selling it on your behalf. And that's another type. You can have exclusive or non-exclusive distributors, and keep in mind that all of this is relevant, and what is most relevant is how you have, what leverage you have over the distributor or in terms of your negotiations. If I'm one of 10 competitors selling a product to one distributor, if I sit there and I say I need an audit and termination rights in this contract, and they say, well, we're not going to do it, and then you say, well, we're not going to sell you our product, they may just say, well, forget it, we don't need your product. You may need your distributor more than they need you, and for that reason, you have to be realistic about what types of contractual provisions you're going to get. And so your ability to not only obtain these contractual provisions and also will depend on sort of the relationship, but obviously your ability to sort of require them to report to you or supervise or monitor them and their activities and what they're doing. It really runs the gamut in terms of your issues that can come up, and I'm going to talk about that in a little bit as to how you sort of have to frame your due diligence in that situation. One of the most difficult things is sub-agents and sub-distributors who are in the chain of distribution of your products or services. And here we run into a real issue because you may not run all your sub-agents or sub-distributors through your due diligence process, and that is very difficult. Johnson & Johnson got into trouble in China. Why? Because they had a huge network of sub-agents and sub-distributors, some who were assigned to individual hospitals. That's how local it got. And they never had the effort, they never had the resources nor the time to run through the due diligence process, all these sub-agents. They went to the Justice Department and they said, look, they threw up their hands. They said, we can't, do this. It's just not realistic. And the Justice Department's response is, look, you're responsible for these sub-agents. We expect you to run some type of due diligence through these sub-agents, or you can just prohibit your agent from using sub-agents or requiring them to bring them to you for due diligence purposes. The thing is, the numbers were so overwhelming in the Johnson & Johnson case that the Justice Department had to back down a little bit and give them some more time to get their sub-agents under control. The problem is that there are thousands and thousands of sub-agents who could be used, and you have to sort of figure out, given the numbers of agents that you have, is it realistic and how far can you get into the weeds on sub-agents? You may need to develop a sort of lower, what I would call sort of a lower threshold of review for sub-agents of some sort, or try to take some creative efforts towards them. Consultants, to me, are more, and I'm going to get to vendors in a second because that's a trickier issue. Consultants, to me, are more like people who you use in the political context, consultants who are going to help you in lobbying or whatnot in a particular government, and those people obviously are another type of third-party intermediary. The one that we need to spend a little bit of time on are vendors or suppliers. And it's interesting to me, but people just, I've seen too many people just sort of blanketly state that, okay, we have to put all of our suppliers through a due diligence, our third-party due diligence process. Well, that depends, in my view. Let's start first with the UK Bribery Act, which is not being enforced, and I'm not saying anybody should sort of design a program that is only based on the UK Bribery Act enforcement or to respond to it. It's hard to ignore it because it's a law that's on the books, but it also is, we have to be realistic. It's not enforced now very much, and it's not going to be enforced for years because of all the political mess that's going on related to it in the Serious Fraud Office, the SFO. But nonetheless, on the UK Bribery Act, the term associated persons is used with regard to third parties. And it is and I think the SFO's interpretation and everyone's interpretation is that associated persons does include your suppliers, so that you would have to include your suppliers in any type of due diligence process if you're going to try to meet the UK Bribery Act. Under the FCPA, it's a different question because the way the law is written, there are a couple other elements that have to be satisfied, which is to obtain or retain business and the business purpose test. So, for example, let's say I have a supplier that supplies me with, cans of Coke to put in my vending machine, and for my employees, and I have a supplier. Do I need to run that supplier through my due diligence process? The only way that I would ever have to run a supplier through my due diligence process is if I can show that, or if I am concerned that a payment that I make to them will be used for, or could be used, let's say, to bribe somebody that's going to, in the foreign government by the supplier, that's going to help me to obtain or retain business and is going to be used for a business purpose. In other words, that I'm going to benefit through that payment in a business purpose type of way. And I think you have to draw lines between certain suppliers. There are suppliers, for example, that can include, okay, we're not only going to supply you with these, but we'll get you the regulatory approval to use these particular items, and we can, sort of do that as part of the supply process. Well, that's a different situation, and you would have to run that person through due diligence. But you need to draw lines and not just say that every vendor or supplier, Staples that sells you office supplies necessarily has to be put through the FCPA process, unless you get to that point where the obtaining or retaining business and the business purpose test is actually satisfied. So that's one thing to be careful about when you're doing your due diligence program. The Justice Department and the SEC made it very clear as to what they're talking about in terms of due diligence. They do not want a vanilla due diligence plan that applies the same standards to everyone. They want a risk-based due diligence program which builds off of your risk assessment, which is the key to tailoring your compliance program, and they emphasize that. So they want to see due diligence that varies individually based on the industry, the country, the size and nature of a transaction, the historical relationship with the third party. For example, if you just started to deal with a third party and you have another third party that you've been dealing with for 30 years and have no problems, that obviously is going to inform what type of due diligence you do. The other criticism that the Justice Department leveled against compliance programs is they basically said people are spending too much time on gifts and entertainment. We don't care about pens. We don't care about hats with logos. We don't care about any of that stuff unless it's systematic. What we want you to do is focus on the big risks. And it's a good point. Where are the risks? When you deal with foreign governments with a big contract, or you're using third parties to help you, we want you to focus on those issues, and we want you to design it in a risk-based manner and carry it out in a risk-based manner. So one of the things that they talked about is the way to reduce third-party risks is when the company analyzes the issues that I've listed before, the qualifications and associations of its third-party partners, the business rationale, which is huge, and we'll talk about that, supporting the use of the third party, why do you need the third party, and what type of what services are they going to actually perform for you. In the contract, we want to see specific listing of the services they're going to provide. What kind of payment terms in comparison to the market comparability analysis, and obviously the timing of the third party's introduction to your business. Did it just happen today, or did it happen a long time ago? That type of thing is important. And what's addition to the due diligence process, the other point to look at is how do you remediate your risk beyond your due diligence process and identifying red flags and dealing with them and investigating them. Well, there are many ways to remediate a risk that's going to survive, and that, your due diligence process, meaning you've identified the risk, you're going to go forward with them, but you have to remediate the risk, and you do that through certifications of commitments to comply with the law. You inform them of your compliance program. You get a commitment that they're going to comply with this, and you may include them in your training program. Or if they have their own training program, you're going to review it to make sure it's fine. You're going to paper this in some ways with certifications and other commitments that you can then use and claim that this is remediating the risk of that you've identified through your due diligence process. So let's talk about some of the practical due diligence principles. Let's go back to the law for a second. What does the term due diligence mean? And it does not mean, a sort of prosecutor, an FBI investigation of a third party, digging through everything, speaking to everyone. It means reasonable inquiries. So this is not a fact-finding process beyond a reasonable doubt. There's no burden of proof like preponderance of the evidence. I hate to use the Potter-Stewart line of, you know it when you see it, but your gut is going to tell you when you're in a comfort mode and when you're not in a comfort mode. The more that you can carry out and process that is sort of in a written policy, the better. And there are going to be three basic principles that have to be critical principles, in my view, to protecting yourself and to making sure that this due diligence process is going to survive scrutiny and is going to give you the protection. There is no way, and I hate to take this moment to say this, but there is no way, if you conduct a legitimate due diligence process and do it in good faith, that anybody is going to ever go to jail for the misconduct of a third party, unless it is, basically done in bad faith. If you follow these principles, you are protecting your company. So the three most important things are documentation, and I'm going to say over and over because the next slide is about it. Due diligence file for each third party. Now, documentation electronically, or you can be a Luddite like me, and you can put it into, actually into a written file, with actual documents. It is critical to document the things that you do, and we'll talk about that in a second. Advice of counsel, okay? The only value of an outside counsel like me is, I'm being facetious, but is where we can really help is to review the file and give you a quick and dirty opinion, which basically says, this looks fine, go forward with it. With the third party, and now you have not only that you carried out a very careful due diligence process, but you have something else. You have the advice of counsel that you can rely on. You can rely on the advice of counsel and say, not only did we do all this, but Volkov looked at this and told us it was okay, and we relied on that, and that is very valuable in terms of showing the absence of corrupt intent. You did not act sloppy. You did not put your head in the sand. You dealt with every issue. And, reasonable people can disagree, but whatever, you relied on this advice of counsel. Okay? The third thing is what I call the vertical element of your due diligence inquiry. You have to have controls in there, or certain points in your investigation or your due diligence process where you vertically escalate the matter to more investigation, a deeper dive on somebody, and the reasons for it, and then you develop more evidence of that relating to that person to deal with the red flags you've identified. Vertical risk evaluation is critical in your due diligence policy. You cannot have a flat, vanilla policy. okay, where everybody is run through the same way, the same exact way, and nobody's ever elevated for further examination. So you use your best judgment, you use your good faith, you explain reasons for your decision, and then the challenge is that within the organization, within your company, you have to sort of assemble your own mechanism to get all the information that you need. You're not going to be able to create the due diligence office within a particular company. You're going to have to get access and build in a flow chart of sources of information that you can bring together from different parts of the company to get you the information that you need to put into that file and go from there. So no one-size-fits-all solution, which is a standard saying that everybody has to take in terms of one-size-fits-all. Documentation, documentation, and documentation. What I mean by this is documentation. Folks, if there's anything, please make sure you document what you're doing and why. The reason that I say this is because if you go into the Justice Department and you said, well, look, you know, we knew this guy broke bad. We found out this guy broke bad, and, you know, we did all this beforehand. We did this, we looked at this, we talked to these people, we talked to some of their references, we did this. And the Justice Department will say, well, show us the paperwork that shows this. Where are the emails? Where's the whatever? And you say, well, I'm telling you it happened. They won't believe you. They will not believe you. They're not going to credit it. They're not going to credit it. The easiest way to get the credit is to show them the file and let them look at it ad nauseum, okay? The due diligence file, to the extent you can. You cannot do this for everyone, okay? And I understand that. There are so many low-hanging fruit in terms of the due diligence process, but you're just going to run them through the system and put the paperwork in there. That you're going to do because the ones that you have in the Netherlands, the ones you have in Denmark or whatever, those people are not going to be people that you're going to spend a lot of time on. It's going to be your problem children. Your problem children, you know, in China, your problem children in Russia. These are going to be the people that you're going to run a log about, and you're going to keep a record of everything that you do in the due diligence process, and you're going to build that file, and the file at appropriate points are going to have, you know, key decisions are going to be made in that file based upon the information that's contained in the file, and you want to have a good record of that as you're going along in this process. So what are red flags? Red flags, you know, I used to think, you know, all the people in the corruption field thought they came up with the sort of term red flag, and it turns out, as we know, it goes way back to even, you know, money laundering, and goes back even before that. It basically is a circumstance which, you know, indicates an increased risk of corruption. And these are the existence of these red flags, and your failure to deal with them will be listed by the government as, you know, here's our proof that the company acted in a willful blindness way. They acted with deliberate indifference. Here's the flag that was obviously present, and they did nothing about it. They ignored it. As a matter of fact, there was an email saying, should we be concerned about this issue? And somebody wrote back and said, nah, forget it. We don't have to worry about it. That's the type of thing you got to worry about. Due diligence process is for you to identify and then resolve the red flags. Now, what do I mean by resolve? There are many, many ways to resolve red flags. First off, you can dig a little deeper into the facts to confirm the presence or absence of the facts, okay? For example, let's say there are allegations that a particular person in Brazil was involved in a domestic corruption matter, and there were reports in the press about it. What do you do with that? Well, the first thing I always do is, obviously I'm going to get as much information as I can from the media sources, but I'm going to ask the third party. You ask a direct question of the third party, you get their response, okay? And when you get their response, that's going to give you a way to evaluate the substance of the red flag. If they say, well, that was, you know, that was manufactured by my political opponents, and it went nowhere, it was investigated, and the investigation was closed, that's going to help you, okay? You may do your own additional factual investigation, and we'll talk about the ways to do that in a little bit. So there's an additional factual investigation that you can do to sort of resolve the red flag and nip it in the bud, as they say. Or for example, you can also look at creative compliance controls to eliminate or reduce the risk from the red flag. So you can get written representations or certifications, not just the representation that says this person has not and will not and, forever, swears will not violate the FCPA. Think creatively about specific representations or certifications you can get which go towards the specific risk itself. What do I mean by that? For example, let's say you have a third party that is actually a government employee or government official, but in a different part of the government than your third party is going to be dealing with. There are ways in which you can get specific representations and certifications from that person saying that they will not use their government position in any way to benefit the company in its efforts with regard to its dealings with the other part of the government. And we'll talk about that situation. So use specific representations and certifications in addition to the general one, which shows that you identified the risk and you got rid of the risk. You reduced it, okay? You also can exclude people from certain business and geographic areas, although I don't like to do that, or dealings with specific government offices. Obviously, a person can't lobby themselves, so you don't want them to be, if you have a government official who's involved in a third party, you don't want to have them lobbying themselves for obvious reasons. You can put in additional training, monitoring protections. You can put in other certification requirements, more regular certification requirements. Look at what was done in Morgan Stanley in terms of sending out notifications on FCPA, is important to us. They sent out a lot of emails. They got certifications on a more regular basis from people about their compliance with the FCPA. So now we get to our 10-step presentation. I wish it was a nicer recipe, but this is basically the 10 steps, and Barney Fife will help us with step 1. And I'm going to take you through 10 steps rather quickly in terms of how you conduct due diligence inquiry and addressing the 3 principles that I talked about earlier. Step 1 is your initial identification of the third party and who is the third party, and you're gathering as much information. And that should come first from who is the sponsor of this person within your organization. Who came to you and said, hey, I have a third party, or who came within the organization and went to his or her business manager and said, I have a new third party. I want to get this person on board. They can really help us. Here's the way that I think they can help. And so let's get all of this information. How did the third party come to the attention of your company? What is your purpose? What does this person want to, why do we want to hire this person to be a third party, and what specific services will they provide? Why do we need this person, and give us the rationale for it? All of this, again, should be captured in some way in a form or some way, some writing that is then placed into a document, a due diligence file. Step 2, basic information. Now, your basic information, you take your third-party champion who's in your company. They present you with all of the information as the sponsor and everything like that. And the first step that I like to go to, and even include in my due diligence file, is you use an open source intelligence service. And you use and there are many of them. There's, we're inundated with due diligence companies, but you have all of these that you can use, such as World Compliance and others. I've used World Compliance a fair amount. Trace is very good as well. And this is a low-cost and valuable tool for, around $10,000 a year or less. And you run the names of everybody you can associate with a third party and see whether or not there's any initial information about reports of corruption, criminal activity, civil litigation, all of that. You want to include media sources, every public filing you can, and now they're getting a little bit more sophisticated on state-owned enterprises and the ownership of that. The databases usually were pretty weak in that area, but they're getting better because they realize the need for getting accurate information on state-owned enterprises. You also want to have your dynamic searches, and by dynamic searches that means if the information changes 6 months from then, You want to be notified that, okay, you checked this guy 6 months ago, and now it turns out there was just some fresh information came in that he is linked to a corruption scandal. You want to get that notification because it may require you then to conduct a new due diligence inquiry relating to that person. So you want to make sure you have that dynamic search capability. The next thing is your financial credit worthiness and business checks. Somebody in your organization runs the financial background of these people and of customers and other people, and you want to make sure that that information is captured within your organization. And here's an example of where you have to reach out to a different part of your office or a company and find the people who do this and say, look, I want to plug in these third parties and get the information through your database service for financial information. Again, that's included within the file and placed in the file for later review. And believe it or not, basic internet information. I have been pleasantly surprised, and I'll give you an example of a situation that came up. Kroll Investigative Service looked at somebody for a client. They gave, several lengthy reports, and then I decided, okay, I'll go on the internet and also, look up this person and see what I can find. Not that I'm some great internet searcher, but my sons are, that's for sure. But I did it, and it turned out that this guy was the number 4 in line to become president of the country. And Kroll didn't bother to mention that, and Kroll didn't bother to mention that this person's brother is the president of the country, and that the royal family that's involved here was basically the founder of the country. So that made me think, look, how can Kroll miss this, and I can go on the internet and look up, on Google and find this information out. It just goes to show you, look, do the basic internet information check. I usually try to get young people to do it because they're great at finding things and, working their way around the internet. Step 3, we get to the questionnaire and the initial interview. If you're going to have an interview, keep in mind on your sort of vanilla third parties, the ones that are not problem children, you're unlikely to have an interview. On your problem children, you're probably going to have an interview of some sort, and how that's done, there's a variety of ways to do that. Your third-party questionnaire. Everybody has a standard questionnaire with questions, designed to get at some of the government connections, whether or not you know about the FCPA, the third party knows about the FCPA, all of these things, and you get as much information as you can. There's no shortage of need or no reason to hold back on getting information. The more that you get, the better. Obviously, on important cases where it's really, you need to do a lot of work on the third party, you're going to have to do a face-to-face interview. Obviously, I know that that's not possible all the time given the location of a lot of these people, but on really important ones, please try to do a face-to-face type of thing, or even on a good video presentation type of communications device. You make sure your candidate signs the form. The form itself, going back to it, just don't, you've got to try to tailor it. For example, I got information from Kroll in this one case, and I took that information and then used that to ask specific questions in the questionnaire. There was an allegation that the person had a relationship with the president of a country. Well, ask them specifically about that in the questionnaire. In other words, take your basic questions and add to it. Think creatively. There's no harm in asking, okay? And don't try to scare them off with a million questions, but you also want to balance your need for information to get through the due diligence process. You should obviously confirm your third party's willingness to comply with the anti-corruption laws. Some people actually attach basic representations and warranties to the questionnaire. And then you're going to get business references, 2 to 3 business references. Why? Because they're easy, positive things to put in the file that are going to help you, demonstrating why to move forward with this particular person. Those are, 20-minute telephone interviews, 15 minutes that you do with 2 or 3 business references, and nobody's going to give you a business reference that's going to say anything negative. So, going back, some people do have the questionnaire filled out by online. That's the new hot thing, is to have people just go in and put in all the information. That can be done, or a form that can be filled out online to make it easier. I think more and more that's going to be the sort of standard norm. But you want to make sure that there is a representation by the person that they are providing you truthful information as they sign the form. And frankly, I put in language to say that the responses are personal responses. In other words, generated by that person, not by, let's say, a lawyer or somebody else who just filled it out for them. Okay. Step 4 is your red flag response strategy. So all of a sudden, you start to get some red flags that come up from your due diligence inquiry, be it through the open source intelligence process or through your questionnaire, and you're starting to see some things that cause you a little bit of concern. So obviously you have to categorize some of these. Some you're going to just say you got to accept them, okay, or some you're going to have to resolve with a direct question, and the answer that you get, and assuming it's credible and you can make a good rational explanation. Some you're going to have to deal with certifications. Some you're going to have to deal with contractual modifications, such as, if the guy says, pay my mother's account in Switzerland, wire all the money there, and you're going to say, no, sorry, that doesn't work. We got to do it this way, and the contract is modified or whatever. But it is most important to ask the third party about a red flag and document the response. In other words, ask direct, hard questions. You will have to do it. You're just going to have to do it, and it's not that bad, and frankly it makes it easier for you to move forward because you can rest assured they're going to have an answer to it, okay? Now, whether or not it's persuasive to you is another matter, okay, and how you deal with it from that point, okay? Let me also talk about for a moment what I call focused due diligence, and this is the first example of your vertical information gathering process in your due diligence process, in your due diligence inquiry. You're going to have a focused due diligence examination. And when do you do this? When do you elevate this to do something else? In other words, you're going to have to conduct even a greater investigation. And a lot of people then use locally, they'll use various companies like Kreller. I use Kreller, for example, for due diligence follow-ups, and for $2,000 to $3,000 they can do a greater, more in-depth examination, and for a little bit more they do even boots on the ground types of things, and we'll talk about that in a minute. But you have to think to yourself, look at the file and think to yourself, okay, based on all this information, do I need more information to justify that will make this decision to move forward? You give me greater support for that. And if you are in that position, if your gut tells you you want to spend the $2,000 to $3,000 for that, then you go out and you do your focused due diligence, and you hire one of those companies. And I'm going to talk about that in a minute. Step 5 is your focused due diligence, and how do you do this? Okay. And here are some of the concerns I have when you hire Kreller or hire people. You do not just simply say, here is the person, go do a little due diligence on them and give me back a report with a little bow in it or something like that. Okay? You do not do that at all. All right? Because what you're going to have to do is you're going to have to do something where you document, number one, why you're hiring the company. And you're going to have to know what are you trying to get at, what issues. You're going to have to hire them in a way to protect the attorney-client privilege. Make sure, if you're not an attorney, make sure an attorney is involved in the hiring process so that the report goes to the attorney for purposes of this due diligence so that it is protected by your privilege. But 3, you're going to tell them exactly what you want and how you want the investigation to be conducted. Let them tell you what they can do, and then you tell them what you want. You may want boots on the ground, somebody to go around and find out about the reputation. You may want somebody who has familiarity with the local practices there so that you can deal with some of those issues. For example, you may want also somebody to go by and photograph. You have some concerns as to whether or not this is a fly-by-night operation. We had a situation once where a guy in Libya said to us, okay, I have, said to my client, I do this all the time. I have an office in Canada. He gave the address of the office in Canada. They went by the office in Canada. There was no such office. There was nothing. It was just empty land. So for that reason, you want to know that because that can inform your process. You may want to interview some of the local personnel who work with that person in their company. If it's an agent, they may have a small company. You can interview known associates to develop reputational evidence. You have to be involved in supervising this investigation and designing it and thinking what you need and what's going to make your case stronger in terms of the allegations or the red flag that you're trying to deal with in that particular situation. Most importantly, you will tell Kreller, do not write anything down before you talk to me. Here's why, and this is a situation, I'll give you a worst case scenario. All right, I got into a case when I had a particular agent in Nigeria, and the agent in Nigeria was under investigation by the Justice Department. And what happened was that one of the companies, and I'm not going to say who, had done a sort of due diligence thing for the company, and went and interviewed 31 people about my client. 30 people told this company my client was the most honest, law-abiding person in the universe. The 31st person said that my client was the biggest crook and basically was a bag man for the Nigerian oil state-owned agency. And the amazing thing is that they put that into the report, that 31st comment. And it was in the report. And then when the Justice Department looked over this and saw that in the report, that was the focus of ad nauseum amounts of questions, concerns, arguments, that the company had knowledge that my client was a crook and nonetheless went forward with it. That is what I mean when you have to be careful, because these people do not know how to draft these reports thinking that the Justice Department is going to look at them. So please be very careful with your focused due diligence and when you get into that. Step 6 is your review and action steps. You collect all your information. You make sure you have all the evidence. Now you have a focused due diligence, let's say, process. You address and analyze the information in a legal memo of some sort. You will build an action plan. In other words, your action plan is going to be, what else do I need here to make this deal go forward? You're going to have market comparability analysis. You're going to reevaluate your business plan maybe. You're going to have written assurances and contractual modifications, okay? Step 7 is your very valuable creative action plan. And your creative action plan is going to be all of the types of things that you can do that can ameliorate or reduce the risk and show that you are justified in moving forward, okay? These are some of the ideas. You can, like I said, you can restrict third-party business or specific people in the third party. If it's a company and let's say it's 3 partners or something like that, you can, tell one of the partners that they can't be involved in this part or this part of the business, okay? After that, you can develop more specific assurances beyond your standard ones that I talked about in terms of, ownership. There's no foreign ownership. There's no pending or past investigations. You can have one, or allegations. You can have a representation, okay, that I've never been investigated to my knowledge as a third party by any government relating to corruption. You can have an absence of formal and informal ownership interests. There are allegations, for example, like in Angola, that the government has a lot of, ownership interests, secret ownership interests, or cloaked ones in various private entities. And you can get, if that's a particular risk, you can get a specific, representation and warranty as to that. So be creative, think creatively, try to get down to the nitty-gritty issue. What is it causing you concern? And then say, can I draft a contractual type thing, representation and warranty that will help me? You're also going to make sure you carefully describe all of your services you want to, that the third party is going to provide, so that you can, bolster your justification. Like I said, you can have them participate in training. or to make sure that they have a comparable compliance program. Some other things is you're going to get indemnification or investigation costs or anything like that. And probably, and I know this is right at the end here, but one of the most important points that you need to build into the system is, and this is where you need your internal auditors and you need your financial controller to work with you on this, but you have to look at your invoices, and you have to make sure that the invoices are not paid, and I include this now in contractual provisions, that the third party is going to provide a detailed invoice detailing all of the services that they provided for that particular month, and in the absence of providing such detail, we're not going to pay you, and include that. In other words, that sets up you have a contractual requirement, and then you can set up an internal control to review these invoices to make sure that there's adequate specification as to the services they provided before you pay them. Okay? People focus a lot on commission levels in terms of document payment terms, and I don't have a knee-jerk reaction to commission levels. 5%, 7%, 3%. There's no rule of thumb. The most important thing to me is to look at what is, par for the course, let's say, in the market. If you can have a comparability analysis or some sort of statement about comparability, that is important with regard to commissions. I find that people sort of too much, react by a knee-jerk fashion saying, oh, 5% is prohibited. Well, that's not true. Remember 5% of what? Also, agents, in terms of percentages, deal differently than distributors. Remember, distributors, the percentages are a lot higher in terms of their commissions. That's because they provide a lot more services, often marketing and other stuff like that, and the way that they mark up the pricing is a lot different in terms of they buy it at wholesale and then go up to a retail amount. So be careful with regard to this now in terms of your creative action plans. I call them the CAPs. Step 8 is your audit and termination rights, and this always depends upon how much leverage you have, how broad are your audit rights. Your audit rights should always be not limited to the transactions related to your business with that third party. Your audit rights are always key to, you have to have the ability to come in and audit not only their books, but their documents, their programs, their compliance, everything in relation to their compliance with the FCPA. Always in relation to determine whether or not they are in compliance or have complied or will comply with the FCPA. So do not restrict it. Also, I will make one suggestion. If you have the resources, do a few audits. Once the message gets out that you do a few of them, I'm not saying, it means one thing when you sit there and say, look, folks, in advance, we're going to do some audits. We're not telling you where we're going to show up, but we're going to do some. That will improve the performance of all of your third parties or your distributors. A lot of people have distributor meetings, and I encourage people to say, look, we're going to exercise these audit rights at one point, and we're just telling you in advance that it's important to us, so please make sure that you're ready for an audit, and you'll see the performance improve, okay? In terms of other provisions, you need to require some cooperation with the government investigation. If there are real concerns about whether or not somebody is complying with the FCPA, you can withhold payments. You need to include withholding rights and appropriate triggers for that. You would like the people to keep books and records for 5 years. The statute of limitations is 5 years. And I'd like to use as my termination trigger, if I have a reasonable belief that the third party or its agents or sub-agent is violating the FCPA, then I can terminate the deal. I can walk away from the deal. Now, sometimes you can't get everything that you want. I mean, look, that's the story of life, right? You can't get what you want. And you're going to, the one thing I would include in your due diligence file is you're going to document the fact that you requested certain things in negotiations and you didn't get them, but nonetheless that you requested them. and that you negotiated for them. You want to make sure you have a record that you asked for these particular items, even though you know that with a distributor you may not have that much leverage or ability to do that. Step 9 is you review and approve, and here is where you have a thick file or you have a file, and internally you're going to have your business people, your legal people, and your compliance people review and approve this going forward. You're going to document the steps. You're going to complete all the follow-up that's required, and then you're going to hand it to your outside counsel, and let's say you hand it to Volkov. He looks it over and hands it back to you with, here's a page-and-a-half memo, which basically says that I have not identified any significant risk of a violation which would prevent, or risk of violation, which would prevent the company from engaging the third party. And that's what you want to do. And you want to put that near the top of your file because that gives you your advice of counsel. It doesn't cost a lot of money, and it's worth it on your, particularly on your problem children. And this is the issue now where, and it's the last step, but step 10, where you have your monitoring plan, and you're going to watch over your third parties, particularly your problem children. You're going to risk rank them. What countries are you operating in? What other intelligence do you have that indicates certain people may be in trouble? So your monitoring plan is going to focus on one thing that I talked about already, which is your invoices and making sure that the people are actually performing the work, and the payments are commensurate with the work that they're doing. Your auditors and your controller are going to help you with that. You may decide on some risk rank basis to update the due diligence. Do your own investigation. Don't even talk to them, but do some of the early steps and see what's going on with some of your top 10 problem children. You may choose to exercise an audit right and go into one particular place and take a look at them and see what they're doing. You also can increase training. One thing I like to do is there are a lot of things in terms of compliance certifications and emails. There are things that you can just document and build through getting more certifications and sending out more FCPA compliance emails which say this is important to us, we urge you to do that, to comply, and if you know of anything, please report to us, anything like that. So think creatively on your monitoring plan. This is where you want to try to identify people who may be your problem children at the beginning and try to build a better record of steps that you took to watch over them. Well, my last point is on pushing the envelope, and one of the hypotheticals in the, and I don't just like Daffy Ducks, that's not the reason for using pushing the envelope, but is that one of the hypotheticals that the DOJ and SEC used in the guidance was really kind of interesting in terms of third parties. Here you had a company, Company A, which hired a local distributor to sell their products to a government agency in a high-risk country. The red flags were that the distributor required a significant discount or rebate to cover its costs, and they requested they wanted to use a local partner, which includes a foreign official from a part of the government. This is what we were talking about. In other words, so you had somebody from, let's say, the Ministry of Water who was a partner in this third party who was then going to be used to secure business from a different part of the government. Now, talk about a red flag. And the Justice Department's or the guidance response I thought was fascinating, that they said that there is nothing inherently illegal about this. Using a third party that is recommended by the end user, which to me, that's a big red flag. If you have sort of a state-owned enterprise that says, here, they'll use this, we recommend that you use this third party. Or even hiring a government official to perform legitimate services on a transaction unrelated to his or her government job. These facts obviously raise red flags that warrant significant scrutiny. But the thing is, what they said right after that was further diligence to examine the relationship among the parties and written representations and warranties from the foreign official concerning his or her role in the transaction. In a sense, what they're saying is, look, they, in a sense, mapped out what they expect you to do. They're giving you guidance as to what they expect you to do. You may need reps and warranties. You may need to go forward on this, but whatever it is, you're going to have an action plan and you're going to do it. A lot of people, I think, prior to the guidance would have said, forget using this government person who is part of this third party, who's one of the partners of the third party, particularly because this person was recommended by the government itself. And I was very surprised, and I think it gives a good safe harbor, in a sense, and good guidance in terms of how you can take creative solutions and instead of saying, no, we can't use this person, come up with solutions to tell your business people, yes, we can use them, but on these conditions, and this is the way we have to do it. Okay. Well, we're at the end. Thank you so much. As you know, I started my own law firm. We have 3 associates. We do a lot of anti-corruption work with due diligence, investigations, internal investigations, and other services. Please follow me on my blog, Corruption, Crime, and Compliance, and feel free to send me any questions anytime or reach out to me. I'm happy to help you or just provide any type of advice that you need. And look forward to staying in touch. I was going to open it up for questions, but we're sort of at the end here, and I apologize for that. But please, if you do have questions, please send them to me, and I'll get back to you right away. Thanks again, and send me an email if you would, and I will send you a copy of the slides if you want them. And again, I appreciate your time, and thank you for attending the webinar. Bye-bye.